Narration: calm, serious, cinematic. You're standing on a sidewalk. A police officer approaches you and says, "I need you to stay right here." One question now decides everything. Are you being detained or are you under arrest? Most Americans don't know the difference, and that confusion can cost you your freedom. Today, we're breaking down detention versus arrest under U.S. law, what police are legally allowed to do, what your rights are, and what you should never say or do. Subscribe to this channel for clear, accurate explanations of U.S. law so you can protect your rights with confidence. Let's begin. In the United States, police encounters happen every day. Traffic stops, street encounters, public places, airports, protests. But detention and arrest are not the same thing, legally or constitutionally. Understanding the difference can mean walking away free, avoiding self-incrimination, preventing unlawful searches, protecting your Fourth Amendment rights. This is not anti-police. This is pro-law. Everything starts with the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Under U.S. law, detention equals a temporary seizure. Arrest equals a full seizure of liberty. Both are seizures, but they require very different legal standards. What is a police detention? A detention is a temporary stop where police restrict your movement for a short time to investigate possible criminal activity. This is often called a Terry stop based on the landmark Supreme Court case. Terry v. Ohio, 1968. Police must have reasonable suspicion. That means specific facts, observable behavior. Not a hunch, not a guess. Not your appearance alone. Example, hypothetical. Police see a person pacing back and forth near a closed store at midnight, repeatedly looking inside. That may justify a brief detention. What police can do during detention, during a lawful detention, police may ask basic questions, ask for identification, state law dependent. Conduct a pat-down only if they reasonably suspect you are armed and dangerous. Temporarily restrict your movement. Police may not. Search your pockets or phone without consent or probable cause. Transport you to a station. Interrogate you extensively. Hold you indefinitely. How long can a detention last? There's no exact time limit, but courts require that detention be brief, purpose-driven, reasonable. If police prolong a stop without justification, it may become an illegal arrest. Courts look at time elapsed, police actions, whether investigation was diligently pursued, the most important question, am I free to go? This is the single most powerful question you can ask. Politely ask, "Officer, am I being detained or am I free to go?" Outcomes. If they say you're free to go, walk away calmly. If they say you're detained, remain silent. If they say you're under arrest, ask for a lawyer, never argue, never resist. What is an arrest? An arrest is when police take you into custody and significantly restrict your freedom. To arrest you, police must have probable cause. This means facts that would lead a reasonable person to believe you committed, are committing, or will commit a crime. This is a higher standard than reasonable suspicion. What police can do after arrest. After a lawful arrest, police may handcuff you, transport you, search you, incident to arrest, book you into jail, take fingerprints and photographs. They must respect your Miranda rights, allow access to an attorney, follow due process. Police do not need to read Miranda rights during detention. Miranda applies when you are in custody and being interrogated. Once arrested, you should clearly state, "I choose to remain silent. I want a lawyer." Then stop talking. A detention becomes illegal if it lasts too long, police exceed its purpose. You are moved without justification. You're interrogated like an arrested person. If that happens, evidence may be suppressed, charges may be dismissed, civil rights lawsuits may follow. What if police break the rules? If police violate your rights, courts may exclude evidence, exclusionary rule. Prosecutors may drop charges. You may sue under 42 U.S.C. Paragraph 1983. Departments may discipline officers. Accountability exists, but only if you know your rights. Can you be detained for refusing to answer questions? Yes. Silence alone does not justify arrest, but you must comply with lawful orders. You may refuse to answer questions. You should not obstruct. Silence is a constitutional right. Some states require you to identify yourself during detention. Others do not. Examples: stop and identify states, non-identification states. But no state allows arrest without probable cause. Federal constitutional standards always apply. A man is stopped while walking home. Police ask questions. He calmly asks, "Am I being detained or am I free to go?" Officer lacks reasonable suspicion. He's free to leave. That question protected his rights. Detention and arrest are not the same. Police power has limits. The Constitution protects you, if you understand it. If this video helped you, like the video, subscribe for U.S. legal education, share this with someone who needs to know their rights. Because in America, knowing the law is knowing your freedom.